All right, we're reviewing clips from the Van Dyke trial, which we covered gavel to gavel previously this fall. I want to bring in Michael Koribanics to talk about this. Now, you're a former prosecutor. You're also a defense attorney. And something that you and I were talking about during the break was the fact that the upcoming trial, the cop cover-up trial, and this all relates to a conspiracy, goes back to that night with Van Dyke and that fatal shooting. Now, this upcoming trial is a bench trial. Can you explain to our viewers what that means?
Well, in a case like this, I think it's highly unusual to have a bench trial. In New Jersey, which is my home jurisdiction, you could waive a jury trial. You have a constitutional right to a jury trial. You could waive it, well, actually make application. Usually you would do that if you think that the evidence may be so prejudicial or you think there's such legal perspectives to your case that a judge would grasp it better than the jury.
Right, and maybe that's what we have here, because let's think about this case, because I think a lot of our viewers are interested in how the Van Dyke trial is going to play into this conspiracy trial. So we had a conviction in Van Dyke. Van Dyke was found guilty of second-degree murder, 16 counts of aggravated battery. That was back in October, all for the death of Laquan McDonald. Now, circling back, the allegations in this case are that the officers who were involved are charged in a cover-up surrounding that fatal shooting. All of them have pled not guilty to conspiracy, official misconduct, and obstruction of justice. So the fact that there's a conviction in the case with respect to the shooting, a murder conviction nonetheless, does that play into the decision-making of the defense attorney in divvying out that advice about whether or not you want a jury of your peers to make that decision or a judge on the law? Is that something that you'd be thinking about from a defense perspective?
Well, yeah, it's something you definitely would be thinking about from a defense perspective, because it's very much... I always get nervous on a bench trial, because with a jury, you have to convince 12 people for the state, and we always have the chance of having one juror who may go your way. You know, you better be very careful of how your evidence is going to unfold, because you may think you have a case that a judge won't convict on. But as these trials unfold and people testify, you may be put in a position where the judge has no choice, and that's a problem.
Well, that is a problem. But so let's talk a little bit about these actual allegations, because Van Dyke is the one who was convicted of second-degree murder. Okay, so that's not part of this case. This is all about a conspiracy, and the allegations include, so prosecutors say that all three failed, falsely claimed in their reports that Laquan McDonald, the victim in this case, had battered and assaulted and attacked Van Dyke. Now, if everybody remembers, for the viewers here, a lot of what was alleged or what was written in these reports was debunked by a dash cam video, and the defense has argued that the fervor to bring this case to trial is public outrage because this dash cam video was released. So what, Michael, do you have to show with a conspiracy? Because that's the root of this case, that conspiracy charge. What are the elements of that?
Well, a conspiracy we always refer to as a darling of the prosecutor. Number one is you have to show that all three of these people, police officers in this case, agreed. They came to an agreement that they were going to work together to cover up the facts of this case to avoid prosecution.
Right, and so that's the key, right? That there's an agreement. That's
Correct.
That's the beginning. And then from there, you have to show that they all were active participants, right?
Correct.
So it's going to be interesting to see what happens. And we do have, because we covered Van Dyke gavel to gavel, we have a little bit of a preview about the type of evidence that we're going to see, and we're going to break that down with Michael. Right now, we do have to go to a break, but we'll be back. Make sure to stick with us. That was the medical examiner in the Jason Van Dyke case. We're reviewing this testimony in anticipation of a trial that is set to begin tomorrow, the cop cover-up trial. All of these cases stemming from the death of Laquan McDonald. Now, the subject matter of the case, we have 3 current and former Chicago police officers accused of trying to cover up the details of the Laquan McDonald shooting. That case is set to go forward tomorrow. I want to bring in my panel here. I have Marni Snyder. She's a criminal defense attorney, and I still have Michael Koribanics here in the studio. Mary Jo, Michael, thank you for being with me here today. There's so much to unpack in this case because we have a trial that already happened. Okay, so we have the Jason Van Dyke trial, Marni Joe, which he was convicted back in October. Now, the subject matter of this case is a conspiracy. Some of the allegations are that the details of this case were altered by the other police officers involved, and that basically they wanted to show that Laquan McDonald had been an aggressor in the case, and that's why Van Dyke shot him. Now, what's the impact of that prior trial on the conspiracy trial set to start tomorrow?
Well, we won't really know until it begins, but it's another opportunity for the lawyers to all use statements of people who testified under oath during that first trial to see if they can bring out any inconsistencies in that testimony, and to see if they can really make argument that Laquan was the aggressor in this case. And that's really what they have to show to make their statements to the investigating officers other than them true.
Right, and so that'll be interesting to see if there's any impeachable material in there. I want to bring you in too, Michael, to talk a little bit about this. What about that dash cam video? Because that dash cam video, a picture says 1,000 words, right? So what's written in the reports was at odds with the dash cam video, presumably a large part of why we saw a conviction back in October.
Well, it really is confusing how these excuse me, officers could think that they could give these statements inconsistent with the dash cam when they know it exists.
And that's certainly going to be a problem, and maybe in this case too. Now, Marni Joe, so the dash cam video is what it is, right? So we've seen it. It went viral. There's probably no one that hasn't seen it at this point. But is it going to matter each individual's role? Because let's not forget, we've got 3 people on trial with respect to the conspiracy. So how do you parse that out to show who's involved and who's not?
I haven't taken a look at the indictment recently, but we can remember that there are a couple things going on here. There's the action of the cover-up, and then there's their conspiracy to work together to do that. And so if they are lying on police reports, that in itself could be an issue. The way that they lie, even when there's dash cam, is because over and over again, juries have acquitted police officers of killing people in this country, black and brown men mostly. And so, you know, I think that the officers figure that if they can describe on the scene why they felt differently than what you see, you know, the same type of defense that the officer who was convicted tried to put on, then they have a shot at doing that.
Yeah, and Marni Joe, you bring up a good point, because obviously juries, it's playing up to the juries in certain cases. This upcoming trial is going to be a bench trial, probably a defense decision, because conspiracy cases are pretty complicated, so maybe they feel they've got a better shot with a judge. We do have more on the Jason Van Dyke trial. We're going to review the medical examiner's testimony. Now, this was critical testimony in the Van Dyke case. Let's take a look. Case talking about the injuries in the course of her examination. Now, something I want to talk about as far as the case we expect to see tomorrow, the allegation is that March, so he's one of the officers who was involved and was Van Dyke's partner, so that's an important fact, allegedly instructed another officer on the scene to include false information in the report. So, Marni Joe, let's bring you in to talk a little bit about that. So, if you have a mastermind and then you have a couple of followers, does that matter for the purposes of a conspiracy case? Can somebody say, I was just following directions?
Well, that's why they don't all have the same attorney, is because the likelihood is that the attorney of the 2 police officers who were instructed to do something are going to argue that they were just following protocol, that they can even argue that they thought that fact to be true, and they included it in the report, not from their first-person point of view, but because they needed that in their paperwork. So there's kind of this paperwork defense, this taking orders defense that's there, and then, of course, trying to get them away from the conspiracy, that they didn't know what they were agreeing to, that they didn't know it was false information. So that's like the intent for the conspiracy. Right, so that meeting of the minds element. Now, Michael, let me talk to you a little bit about some of the other charges. So what about obstruction of justice? Whether or not you meant for this elaborate cover-up, if you're one of these officers and you put something in a police report that you know is not true, are you dead to rights all of a sudden?
Well, the problem with it, and Marni pointed it out a little bit, is that everybody's got different attorneys and different defenses, but the more you rely on that you were ordered to do something, or that somebody told you to do it is the more you put yourself in the middle of a conspiracy. You know, there's that saying, like, if you lay down with the dogs, you're going to get fleas. And you got to be very careful when you have those kind of defenses, because you're being judged with the people you're hanging around with, so it's dangerous.
Right, so I'm wondering, Marni Joe, could that be a primary reason, what Michael brought up, which is true, that there's a lot of these interwoven legal theories that are going to come up in the context of this case involving 3 different people? Is that perhaps why we see a bench trial as opposed to a jury, that maybe there's some value in presenting that to a judge, these alternative legal theories, or towing that line of what tips you over into that conspiracy? Or, like Michael said, the company you keep is going to define you?
I do. I think that it's a strategic decision for a lot of the reasons that you just said. But, you know, if you're going to argue a legal theory, there's no better person to do it to than to the judge, instead of confusing a jury. And so I guess we'll see what all of their theories are, but that really could be it. They also, in some ways, they already know what failed in front of a jury. So maybe they think that, you know, their pick of the judge is better than the jury that they could pick in this political climate or this day and age, and that's why they're deciding on a bench trial.
I certainly think that that was a factor, because they had a little bit of a benefit to get a preview of what was going to happen in front of a jury with Van Dyke, which we know resulted in a guilty conviction. We do have to go to a break, but make sure to stick with us. We're going to be breaking this down in a preview of what's to come here on Law&Crime. That's Scott Patterson, special agent, talking about ballistics in the Jason Van Dyke case. Now, Marni Joe, let me bring you in to talk a little bit about this. I'm not sure how much this particular expert, or the testimony about the actual shooting, how much is that going to come into play in the upcoming trial?
I'm not sure that it really will, but we can maybe take a guess that one of the reasons that these 3 officers want a non-jury trial is because they don't want to have a repeat of all of this testimony, which is really upsetting. I mean, you heard that there were 24 holes in Laquan. I mean, the amount of force that was used against him when he was walking away from police is very disturbing. And they want to get as far away from that murder as they can, and they don't want to have the rehearing of all of that evidence.
Right, focus more on that paperwork and more on that, on
Exactly.
the conspiracy charges. Michael, let me bring you in, because this expert really held his own as far as cross-examination. With respect to this type of expert testimony, ballistics experts, some of this might be relevant, right? Because it talks about what you don't see on the dash cam, and obviously the dash cam is the primary piece of evidence. In fact, the defense attorneys have said the dash cam is the only reason why we're in court.
Well, this witness does a lot of things, and I think he does a lot of things subconsciously to the jury. Number one is he's a supervisory special agent for the FBI. That tells the jury, we're taking this case serious. We're bringing in the best of the best. And you can hear by the way he testifies. I mean, I think one of the things that was really came through, and it just resonates in my mind, I've heard him testify before in this case, is that when he gives a description about a shot being fired and how they have studies how civilians, their natural reaction is to jerk, is to like shrug their shoulders. And I think those kind of witnesses who really speak to the jury and put it into day-to-day common language are really powerful. And I agree that, you know, this is something, as a defense attorney, you don't want to hear this guy again, and you don't want to hear the FBI supervisory ballistic agent testifying on behalf of the state.
Yeah, that is quite a title, and he definitely held his own in that testimony, even when he was being taken to task. We're going to continue to review the testimony in this case. Now, this is Yuri Patrick. He's a use of force expert, and this was some really critical testimony in the Jason Van Dyke trial. Take a look. That is a use of force expert for the prosecution. The last part of his testimony, I think, is interesting. He said that McDonald was engaging in avoidance behaviors. Critical testimony in the Jason Van Dyke trial. I want to bring in Marni Jo Snyder again. Marni Jo, so we hear, obviously, this is a use of force expert. Something interesting that happened in the Jason Van Dyke trial is Walsh, who was Van Dyke's partner and is on trial, will be starting the trial tomorrow in the cop cover-up trial. He testified during the Jason Van Dyke trial, and he said that he believed Van Dyke took necessary action when shooting McDonald. So what's the impact of that testimony going to be? So we know that testimony is out there. Unfortunately, we don't have it recorded here on Law and Crime, but is that going to come into play? That's a sworn statement on the record.
Yeah, it's certainly been recorded on the record, and that statement will come into play if Officer Walsh testifies to anything different at all about that in order to impeach him, to show that he's lying, to show what he originally thought at the time, or an admission. So, I mean, we have to see how they want to get it in and what it can be used for. But certainly, it's something for the prosecution to use against him if he says anything different at all.
Right. And Michael, will that go into an analysis about whether or not you want Walsh to even testify?
Well, that's what I'm thinking. I mean, this is one case where you really very hard to put your client on the stand to testify, because he's already accused of giving inconsistent statements with the fact that were presented to the prior case and presented to the prior jury. And now you're putting him on again to tell a story for another time, which can only confirm one story or the other, but still puts it at odds. This is going to have to be a case, I believe, for the defense to win through very good cross-examination and attacking the burden of proof that's put on the state, not by putting your clients on the stand.
Right, right. And Marni Jo, so just to piggyback on that, isn't it a little bit difficult, though, to contest these charges when we have all of this information on the record, we have the reports, we have the video? Is there the necessity, or at least some compulsion by the defense, to say we have to explain this away somehow?
That remains to be seen. It seems like in some of their public statements, the defense attorneys have been talking about sufficiency of the evidence, that the items that were presented to the grand jury misled the grand jury, and there shouldn't have been an indictment to begin with. And that is something that is great for a trial just in front of a judge, to say, Judge, they don't have it here under the law. They haven't met all the elements, even at a level, just the prosecution's case. Then they don't have to put on anything else. So I'm sure that they're going to be making a motion for a judgment of acquittal at the end of the prosecution's case, and they're hoping they haven't presented sufficient evidence then.
Yeah, Marni Jo, you bring up a good point, because the defense actually tried to get this case thrown out right from the get-go. Of course, the burden of proof much higher for a conviction when the trial actually moves forward. So having a judge take a look at that, if the evidence is truly insufficient, maybe that judge's critical eye will be a success for the defense. Only time will tell. Right now, we are going to go to a break, but make sure to stick with us. We'll be back with more on this trial. We're watching testimony from the Jason Van Dyke trial. This was a use of force expert that was pretty critical to the ultimate conviction of Van Dyke. I want to bring in my panel, Marni Jo Snyder. Marni Jo, you had a comment about this, because it's a little bit like pulling teeth here, right? The defense attorney is really giving a lot of hypotheticals. Wouldn't you agree with this? Wouldn't you agree with that? And this expert's not really shaking from his position that, you know, the officer is trained to assess whether or not there's a threat. What did you make of it?
Well, it's perfectly normal to ask an expert about hypotheticals on direct or cross, and you can do so, but you have to make sure that you're asking within their expertise and their opinion. So you kind of saw him ask, like, well, wouldn't someone with a knife always win that fight? You're never going to get someone who is scientifically trained or trained as an expert or highly educated to agree to a sentence that has the word always in it. So it was a little bit tedious there. And, you know, and I think that it's a hard sell, and you're just allowing the expert to talk more and more about how it wasn't justified to shoot him 16 times when he was walking away, even with a knife.
Yeah, Michael, I want to bring you in on that point. Great point, Marni Jo, because you have to be really strategic when you're cross-examining an expert. And Marni Jo makes a great point. You can't talk in those definites.
Well, you got to be very careful when you cross-examine an expert, because he's the expert. In a good cross-examination, it's always nice to get the expert to agree with you. But you need to have more of a rhythm and a little bit of a quicker cross. He was agreeing, but you don't get greedy with his agreeing. I think Marni said when we were off camera is, you know, there was a point in time where he, you know, should have saved it for closing. Get him to agree with the facts you have, and you put it together and argue for the jury. He's not going to put it together and agree with you that the guy with a knife wins every time. Otherwise, he's saying you don't need an expert.
Right, and that's something that, as from a defense perspective, you have to assess whether or not it's appropriate to get that out with the expert. And I think Marni, Joe, and Michael both made great points here that maybe some of that should have been left to tie their case up with a little bow during their closing argument because they weren't getting what they needed out of the expert. I think sometimes with expert cross-examination, somebody's looking for their Perry Mason moment. It didn't happen here. We do have to go to a break, but make sure to stick with us because more on the Van Dyke trial, a little bit of a preview with what we can expect to see in the cop cover-up trial starting tomorrow. This was the forensic pathologist who testified in the Jason Van Dyke trial. I want to bring my expert panel in to talk about this. Mary Jo Snyder, you're a criminal defense attorney. Now, we hear in this testimony just talking about the trajectory of the bullet, the fact there are no photos. Why was this testimony so relevant to the Jason Van Dyke trial?
I believe she was testifying that Laquan had to be facing Jason Van Dyke when these bullets entered him. And I believe that they were going to get to some cross-examination about whether or not the first bullet hitting him could have turned his body, whether maybe a bullets came off of something else. I don't know if what they're trying to say is that he continued force against the officer after the first bullet, and so 16 bullets were necessary. I wasn't buying it, but I don't know if that's where they were trying to go with it.
Well, sounds like the jury wasn't buying it either, Marni Jo, because we ultimately had a conviction. Now, I want to bring Michael in here. Let's talk a little bit about this. So, obviously, you need to have these types of with expert testimony in a case like this. But isn't that what it really comes down to? Was the force reasonable? And isn't that a tough sell with 16 bullets?
I think it's an extremely tough sell. It's an extremely tough sell when you have a police officer who is a trained servant of the public and he's shooting someone 16 times. That's tough. Maybe you can sell that easier if it's a civilian who's not really trained in these kind of situations, but it's a tough road to travel.
Yeah, certainly, and that's why I think we saw that the jury ultimately convicted Van Dyke. We don't know what that means as far as the charges that these other 3 officers are facing tomorrow, but we certainly know what the underlying facts are going to be, which is why we're really breaking this down in anticipation of tomorrow's openings. Right now, we're going to go to Joseph Plowd. He's with the Cook County Sheriff's Department. Take a listen. That was Joseph Plowd. He's from the Cook County Sheriff's Department talking about an interaction with Laquan McDonald. Now, let me bring my panel back in. Marni Jo, so some of the stuff that we're hearing today, and we're reviewing a lot of the testimony to get our viewers up to speed as far as the facts, but some of this might not really be relevant as far as the charges that we're going to see being hashed out in this upcoming trial. A couple of things we do know, though, that there were defense motions that were brought, and they were ultimately denied. One I thought was interesting, a request to bar testimony from a state expert witness who was expected to testify about inconsistencies in the tactical response reports by 2 of the officers. Now, the court's going to let that in. Isn't that, I thought that was correct because the reports are really the basis for this case. But did the defense have a shot of getting that out?
Well, I think that's a little weird. I understand why that's relevant. That's not what I'm saying. But usually the inconsistencies have to be brought out by, showing that there have been prior statements, who took those statements, what was said exactly. It's just weird that the judge is going to let someone else testify. Well, he said this here and he said that there. That's usually my job as an attorney at closing argument to say, see how I pointed out that he said this one thing this time and a different thing. So I'm not sure what allows this person to make the conclusions that the fact finder is supposed to make.
Right, and you'd think the reports would speak for themselves, but hey, maybe there's a little bit more to it than we know because there might be a different angle, a different twist on the facts that are going to come forward in the next trial. We're moving on. Here's another clip from the Van Dyke trial. Take a look. This is Dr. Lawrence Miller. He was a witness for the defense. He's a psychologist. Let me bring Marni Jo in because you had a strong reaction to Dr. Miller, and you remembered this from when we covered the case originally. And I know the minute he came on, you said, oh. So tell us a little bit about what you thought of his testimony and why.
Well, it's interesting. It's really, really hard, I think, for a jury to connect with okay, these are the signs of stress that a police officer would feel, and so you should excuse this, when the jury is really thinking police officers are trained in a special way to not have to use as much force as someone who might get scared for no reason. So I think in that sense, it was hard for the jury to connect with this. Also, what we didn't see, but what you see if you rewatch all of his testimony, is he only did one assessment of Jason Van Dyke, and apparently Jason Van Dyke said some things to him that weren't true while he was assessing. So the defense really had a problem there when their own witness didn't know that Officer Van Dyke had given conflicting statements. So it was really fun to watch, but it also was enraging on both sides.
Understandable. Now, Michael, let's bring you in to talk about that, because you've been on both sides of the coin. You know, you've done the prosecution, defense. I mean, when your expert says something that is not good for your case, that is maybe something that will lead to a conviction.
Well, when it's unbelievable that you put an expert on to say, hey, listen, a cop may shoot somebody while he's working, but it's okay because that's to be expected. That's
right.
A little bizarre. And then to know that you're leaving them open with statements your client made, sometimes it's better to just, let the expert go. It doesn't always have to be a battle of the experts.
Right, and that's certainly everything that you have to take into consideration from a defense point of view. In this case, may have not inured to the defense benefit. We do have to go to a break, but we will be back breaking down more of the Jason Van Dyke case. This is Jason Van Dyke. He was the defendant in this case, ultimately convicted of the murder of Laquan McDonald. Marni, Joe, let me bring you in to talk a little bit about this. Now, in the clip we just watched, and we're going to watch his testimony in its entirety and talk about what that means for the upcoming conspiracy trial relating to the other officers who were involved or allegedly involved in this cover-up. But we heard in this particular clip a lot of foundational type questions asking about his day, what he did that day, whether or not he had been working the day before. What's the purpose of these types of questions in a case like this where use of force is at issue?
Well, one is he got to parrot Dr. Miller saying that cops think about their kids and they think about all of those things in a split second, which I think that we all would have known. Anyone who has children knows how important they are and how they're always on your mind. So again, like, he got to parrot that expert, no matter what you think of how the expert did. But it's also interesting because we're going to hear the same things from these officers, too, about what they think about when they're observing things on the scene, what they might have been thinking about their children while they were observing Officer Van Dyke shooting Laquan, and why they thought that there was an aggression as well.
Right, and that's all going to be the critical testimony, obviously, in this case, Van Dyke, and we're going to continue to watch that now, but the jury wasn't convinced, because that's the crux of the case, and it is difficult to defend a case like this where use of force is an issue without hearing from that person who pulled the trigger. So we're going to continue with Jason Van Dyke's testimony and then continue to break it down. Take a listen. This is more testimony from Jason Van Dyke. Took the stand in his own defense, ultimately found guilty of second-degree murder, 16 counts of aggravated battery for the death of Laquan McDonald. Now, I want to bring in Michael. Let's talk a little bit about this, because we're hearing his testimony. Obviously, this is critical to the case. It's the defendant testifying, something we don't get too often. But in a case of police use of force, did the defense have a choice but to put him on the stand?
Well, you got to decide what your choices are. When I say that is, you have a choice if your witness is going to testify well. But if he's not going to, and I don't think he testified well, Van Dyke. He seemed to be all over the place. His whole physical presence was like shock, scared. He didn't seem too believable. The one thing that struck me in the testimony we just listened to is he's talking, part of his defense is that, he was under stress, he reacted, things were happening quickly, he didn't know what's going on. But yet when it's convenient for him, he notices a police officer, another police officer. He's pointing his gun. He's doing all these things. And it's just very inconsistent. And I just thought it was, I think they would have been better without him, quite frankly. I think he might have sealed his own fate.
Michael, that's a really good assessment and something that certainly the jury picks up on. Marni Jo, what do you make of that? Because that is true. You have somebody saying, I'm in this distressed moment, I'm, acting maybe differently than I would normally act because of the circumstances, but yet I have a keen eye for certain details that benefit me. Is that something a jury sees?
I think so. I think they wonder why some things seem clear to you and some things don't. And I don't think juries are stupid. I think they know that you prepare for your testimony. I don't think it impresses them that you're being honest, that you couldn't remember a street. I mean, if you remembered it, maybe it's just because you prepared and sat down and reviewed the case. I don't think that they think that that makes you a liar. I think that they look at credibility more stringently when someone's saying, I don't know about this, but I remember he was feverishly pointing to the left. I think that they say to themselves, why does he only remember some things and not others? And I know that the defense has to have him come out with everything, but saying that other people already have their guns out, to me, makes it so that you're in less danger already. There's a million eyes on this guy with their weapons ready to go if, God forbid, he attacked someone. I don't think that's a helpful fact.
Right,
so
and you have other people who used restraint, right? So
right.
Certainly all of those factors may have played into the fact that, hey, there was a conviction in this case. We do have to go to a break, but we will be back with more of Jason Van Dyke's testimony. And the question will be, what do we expect to see in the opening statements in the cop cover-up trial tomorrow? This is Jason Van Dyke on the stand testifying in his own defense. This is a trial that we covered gavel to gavel earlier in the fall. Now, why is this relevant today? Well, three officers are being charged with covering up the details of the shooting that was the subject of this trial. The prosecutors are arguing that these three men began working to conceal the details of the shooting, the very shooting that Van Dyke is testifying about right now, within hours after it happened. So Van Dyke's testimony absolutely critical to the cop cover-up trial, which we will be live streaming here on Law and Crime tomorrow. I want to bring in my panel. Marni Jo, let's talk to you first about Van Dyke on the stand. So obviously all of his testimony, that's going to be the basis for these conspiracy charges, right? Because the argument is that these officers reported that McDonald attacked three officers and actually injured Van Dyke before Van Dyke shot. So right. Certainly this testimony is going to be relevant.
Yes, I'm not sure if they plan on having him testify, if there's a stipulation, because it is a bench trial, and sometimes without a jury, you can enter into stipulations and hope that the judge is going to understand how to evaluate that testimony and how to do it quickly. But yeah, if he's one of the people that's an eyewitness that contradicts the things that they are saying, after all of these statements, then certainly that would be fair game as long as it's entered according to the rules of evidence. And like I said, I'm not sure how they intend to do that quite yet.
And Michael, so on that point, so obviously this is, we're not relitigating the shooting. Van Dyke was convicted. So this is a completely different set of charges and facts, but his testimony, will that be relevant to tomorrow's case? And could he be the one who says, yeah, I told them to say he attacked me? Is that possible?
Well, anything's possible. If it's plausible, I don't really know, but I don't think Van Dyke could be called because I believe he still has a Fifth Amendment right because he hasn't been sentenced yet. He's got an appeal process he's going to most definitely go through. He's looking at a substantial amount of time. So I don't think this case is going to be as easy to try as the state thinks it is. It's complicated. It's very complicated, especially with the underlying facts. I mean, I don't know any defense attorney who's going to stipulate to facts in this case without cross-examining and having it subject to cross-examination, since they believe whatever testimony Van Dyke gave is hurtful to their clients, otherwise they wouldn't be where they are.
Certainly all of these factors coming into play in tomorrow's trial, a little bit of complication for both the prosecutors and the defense because we had a full trial already. So it should be interesting to see where they go. And again, what we've seen in the public, the defense attorneys for the three men who will be on trial tomorrow in the cop cover-up trial say there isn't enough evidence to sustain the charges. What that means, I think we'll hear tomorrow in the opening statements. Right now, we're going to continue with more testimony of Jason Van Dyke. Take a listen. We're watching Jason Van Dyke's testimony in anticipation of tomorrow's cop cover-up trial. I want to bring in my experts here. Marni, Joe, so we're watching his testimony. I'm not sure what your impression is of the defendant here. Do you think that he helped himself in testifying?
I didn't notice that he did. I didn't think that it was very effective. And I'm interested to kind of hear, I can't remember from when you covered the trial exactly what he says next and whether he stays emotional, but he was so robotic in the beginning and kept saying what we were trying to do, what we had in our heads. But what the jury wants to hear is what was in your head? Were you scared? And were you scared for your life? And he's taking a very long time to get to fear, and also he's taking a long time to get to remorse, because he can say, I was scared for my life. I'm still sorry this young man lost his life. And it took so long to get to any feeling at all. I don't think it was effective.
Marni, Joe, you make a very good point, because juries really notice that, especially in a case like this. Michael, let me ask you, so here, the crux of this particular case with Jason Van Dyke was the use of force reasonable? Was he in fear of bodily harm or death? Was he using reasonable force in response? So is it detrimental to him to take so long to get to that moment where he's talking about his inner monologue and what was happening?
Yeah, I think they really needed to come to that point in the beginning of this, and I agree with Marni, Joe, is jurors want to hear you're sorry for what you did. You know, it was a mistake. It wasn't criminal, it was a mistake. And when you make a mistake, people say, I'm sorry. He never did that, and I think that really, really hurt him.
Yeah, certainly a jury is going to see through that, because the whole argument is, I didn't want to have to do this. I was forced to do it because I was in a situation facing deadly force. So again, Van Dyke was ultimately convicted. So it'll be interesting to see how everything plays out tomorrow. We do have to go to a break, but stick with us. We'll be back. Cross-examination of Jason Van Dyke. Don't want to waste any time. Definitely want to talk about this with my panel. Now, Marni, Joe, what did you think? Obviously, in the cross-examination, really questioning Van Dyke's testimony as far as why he felt that physical threat. What'd you make of it?
Right. I mean, she gave him the softball of why. An open-ended question on cross-examination, and he couldn't hit it out of the park. Instead, he just said, well, what do you mean, with the knife or like all the actions? Well, what stressed you out? All of the actions, right? That's what everyone's been arguing this whole time. Why do you not know your defense theory as the defendant? It was a mess.
And you make a great point, Marni, Joe, and Michael. I mean, isn't that really what the point you want to get across? You're supposed to be taking all of those environmental factors and saying this is why I felt, or assuming that they would be genuine, right? But as far as a preparation perspective, that's a question you should expect to hear.
Well, like Marni, Joe said, it really, really surprises me when a prosecutor, although prosecutors are not used to cross-examination, because not that often defendants take the stand, but you'd never ask on cross an open-ended question. They could have allowed him to give his own summation to the jury with that question, and he didn't seize the moment. And you know, that's a real problem. What was even more disturbing is that after this shooting, and I represent police officers, is, you know, after this shooting, he said, I was in shock. He should have never been allowed to give a statement.
Right, absolutely. I mean, that's always an issue that you have to watch as a defense attorney. We are going to watch the verdict now, the moment of truth. Take a look. There you have it, ladies and gentlemen. Guilty of second-degree murder, 16 counts of aggravated battery for the death of Laquan McDonald. Right now, I have to say goodbye and thank you to my expert panel who helped us break down this case today. Marni, Joe, thank you so much for joining us. I hope you'll come back. I know you're interested in what's happening tomorrow. And Michael Koribanics, thanks for sticking around. You're staying on to join Aaron Keller, the fabulous Aaron Keller, in his daily debrief. The audience should stick around too to see what's been going on today. Well, thank you so much. It's been a pleasure. Thanks for joining me here on the Law and Crime Network. Do not miss the cop cover-up trial openings tomorrow morning. Thanks again and have a good night.